All right, everyone, we are gonna get started with our fifth and final panel of the day. Very excited about this one as well. I'm excited about all our panels, but very excited about this one as well because it includes not just four excellent constitutional law scholars, but a constitutional law scholar who will be publishing in our symposium issue this spring, Dr. Anansi Wilson. The information on all the articles, notes, and published remarks that we'll be publishing in our spring issue is in the program. And if you'd like to subscribe to the Gender Journal, there's information on that at the table out front. We would love to have your subscriptions. And Dr. Wilson's piece, I've gotten a sneak preview. It is excellent, so please keep an eye out. And I will turn it now to Professor Mezey.
Thank you. Before we get started on the panel, I actually wanted to just acknowledge, shout out the amazing staff of the Georgetown Journal of Gender and the Law. So many of you are here. You've done an amazing job, and I just need to especially acknowledge Sienna Hone for her really. It's okay. You deserve them all, and I hope it's not the last. You've really done an extraordinary job of putting together this amazing conference and this amazing community. We're really grateful to you. This being the last panel of a very long, rich, full day, I am going to be and invite you all to be as informal, weird, and off the cuff as you want to be.
Be careful now.
I'm going to briefly introduce each of the panelists, and then we'll jump in. So immediately to my left, your right, Dr. Anansi Wilson is a visiting associate professor of law at Kansas University School of Law. They are an award-winning scholar of law, literary and cultural studies, a racial justice strategist, and an author of creative nonfiction. Dr. Wilson's legal research is situated in legal philosophy, critical theory, political economy, and constitutional law. Their writing and scholarship primarily focuses on the history of Black thought, art, and imagination crafted in response to and resistance against the West. Wilson's work analyzes the ever-changing relationships between race, law, sexuality, power, and citizenship, both in the construction of law and policy and the maintenance of the way we live our lives. To their left, Diane Kemker is an adjunct professor of law at Pepperdine Caruso School of Law and Loyola Law School in Los Angeles, and a visiting professor of law at Southern University Law Center, Baton Rouge, Louisiana. She clerked for the Honorable Baird in the United States Federal District Court for the Central District of California and graduated magna cum laude from Harvard College and was a Mellon Fellow in the Humanities at the University of California at Berkeley prior to attending law school. Professor Kemker graduated magna cum laude in Order of the Coif from UCLA School of Law and was awarded an LLM in taxation summa cum laude from the University of San Francisco School of Law. Last but absolutely not least, Professor Noa Ben-Asher is currently at St. John's Law Faculty, and they've been there since 2023, coming from the Elizabeth Haub School of Law at Pace University. Professor Ben-Asher's scholarly interests include gender, sexuality, and legal theory. Their work has appeared in numerous legal journals and edited collections. Your newest book is out, right? Is it not out? It's about to be out, momentarily out.
Yeah.
They have a new book, Secular Christian Social Justice, which will be published any minute now by NYU Press. Professor Ben-Asher teaches torts, family law, gender, and sexuality. So I'm really enthused and excited to have you all here to talk to. And I thought we would just start with the topic of this panel, and we can digress as soon or later as you choose. So much has already been put on the table in terms of constitutional rights and the possibilities of different kinds of constitutional arguments. But we have an opportunity to think even more deeply about them and to perhaps add others. So I'm going to just invite you to open, each of you, with what you think the best constitutional argument or arguments are for transgender rights right now. And by best, you're welcome to think in any way, by any metric you choose, that is best, most effective, most strategic for the current moment, or more affirming or more dignifying for the trans community. You can choose your metric and your argument.
Mm-hmm. Oh, someone to
I
saw those looks. I saw those
I-
eyes. Okay, well, I will start with the truth, and then I'll talk about the law. So I write in my dissertation, also my first piece, Furtive Blackness, on being in and outside of law, that Black people, in particular Black queer people, are rendered furtive and exist both in and outside of law. Inside of law, insofar as we're always already reachable by its disciplinary arms, but outside of law insofar as that the foundational rights of this nation never fully attached to the Black or Black queer body. So keeping that framing, understanding that we live in the afterlives of slavery, as Adia Hartman would say, there are no constitutional arguments to further the rights, particularly of Black, queer, and trans people. Right? It just never happens. There's always some ways in which we're left out in the cold. We make these arguments, they're inverted on their heads, as we see right now with the 14th Amendment, to further discipline us. Right? Another piece called The Strict Scrutiny of Black and Black Queer Life, I say, look, what we're seeing right now is the inversion, the molestation of the 14th Amendment, whereas now it's being used to strictly scrutinize the presence and the livelihoods of Black and Black queer people. So instead of this being the Equal Protection Clause, it becomes the Unequal Enforcement Clause, right? And so I think that's something we have to take very seriously. And it's poetic and it can be flippant, but I think it's the reality that the 14th Amendment now, as we see, is strictly scrutinizing any type of policy, from the anemic civil rights policies of DEI, right? And that's what they are, really anemic corporate, efforts at some type of making money off of the glimmer of equality, to real, deep, serious work, right, of furthering racial, gender, and sexual equity in this country. So now we'll move on to what we might call the law. Right. I believe in my sisters from Strict Scrutiny when they say textualism is for suckers. But I would say that, if we're going to be serious about this and we want to win over strategically the right, if we can do that, the wrong right, as I would say, you can make just a very clear argument that, number one, we should probably look at whether there is a discrimination based upon sex in the policy, in the law, in the move, in the enforcement, right? Basically following this thing called precedent. And then once we determine that there is likely some type of categorical or equal protection claim here, we look on and we review the government's evidence, their argument, and we test it, we probe it, we see, does it meet heightened scrutiny, right? Again, this thing called precedent, following the law. And we go from there, right? And of course, we can go with our equal protection claims, which is really great. We can say this is sex discrimination, take Gorsuch's argument, right, from the Title VII claim here. But as some people have said with Dobbs, and I think that Michelle was someone that made this argument kind of earlier on, but also critical race theorists and Black studies, Black feminist studies scholars have been making this argument around reproductive justice, is that this could very well be a 13th Amendment violation. If we think about this very seriously, about the badges and incidents of slavery, the heart of slavery is the lack of control over one's reproductive labor, right? And oftentimes we think about this through the lens of women, the idea of sexual violence and being forced to reproduce or being disabled from reproduction. But we also must think about men as well, because they're also being forced to produce and engage in sex, right? To be forced to look a certain way. We think about even the haircuts enslaved men were made to have, the hairstyles enslaved women were not able to have, and the idea of being sorted and made to act in the ways of men and women that are alienated from West African traditions. So even in the creation of the slave ship and the moving of these bodies, stacked 16 people high, 32 wide oftentimes across the musty ships in the Atlantic, you have the ungendering of an entire people. So you have the forced identification with a gender binary that was never endemic, was never systemic, and was never indigenous to these West African folks. So when you have a government that is saying you must define gender or sex in these particular types of ways, or you must act, you must speak, you must dress, you must style the natural follicles of your hair in this way, you will literally have the essence of chattel slavery reanimated. So I would argue, for me, these are nothing but the badges and incidences of slavery. And as we've democratized the 13th and 14th and 15th Amendments in every other way, we might as well do this for trans folks as well, across race.
All right, well, it's a hard act to follow. Not just an act, but yeah.
Poetry is power.
Of course. So the title of this panel, of course, is the best constitutional arguments for transgender rights. And so one of the first things we would have to define then is what we mean by best. I think it's important to distinguish what we might call the winningest arguments from those that are the best in the sense of providing the strongest intellectual, moral, maybe legal foundation for the protection of transgender rights going forward. Now, of course, some litigators might disagree, and I respect that, of course, and we've had presentations from many successful litigators on the front lines of these issues, and I tip my hat to them and to others who are out working in the field doing what it is they need to do, right? I'm not here to criticize that. For the litigator, the best argument is the one that works for this client right now. But my own view is that civil rights impact litigation has too often seized that best right now argument in ways that become problematic later on, that require, for example, pandering to those hostile to the claim, presenting the claimants in a way reflecting something less than the whole truth in order to secure a desired result. I'm not criticizing that as a litigation strategy, but I am criticizing it as a strategy of constitutional law because I think it has trapped us in places we don't want to be, defending positions we do not actually hold. This is especially true, I think, about transgender rights. But to make a comparison, if we consider, for example, the privacy rationale for the protection of reproductive rights, the winningest argument to make in the early 70s, building on the contraception and marital privacy cases. But I would submit it was not the best argument to make in the sense I mean, and ultimately it collapsed, I think, under the weight in part of its own internal weaknesses. As the late Justice Ruth Bader Ginsburg suggested at various times, a gender-based equal protection rationale would have been better, by which she meant, I think at that time, constitutionally sounder. But it would have required making a connection between access to reproductive health care and the end of compulsory maternity as essential to women's full civic and economic participation. Perhaps that argument was not as well developed as it needed to be in the early 70s, but it's a better argument. And in my view, the reestablishment of full reproductive rights for pregnant and potentially pregnant persons will depend upon it. As Justice Ginsburg expressed it in 1978, not only the sex discrimination cases, but the cases on contraception, abortion, and illegitimacy as well, present various faces of a single issue: the roles women are to play in society. Are women to have the opportunity to participate in full partnership with men in the nation's social, political, and economic life, right? A little dated in a certain way, but of course you see what she's getting at. Of course, cases about transgender rights, bathroom access, employment discrimination in settings as various as the Capitol building, the military, the carceral setting, the sports locker room, also present various faces of a single issue: the participation of trans people in the nation's political, social, and economic and civil life. Trans people also face a threat that cisgender women as a group never have: an attack on the reality of their experience and on their very existence. This is already cognized in equal protection terms. Justice Ginsburg's critique of the privacy rationale is inapplicable in that sense. But other parts of equal protection doctrine are as problematic for establishing trans rights, I would argue, as privacy was in the reproductive rights context. So I know we're urged to talk about the best arguments, but that requires ground clearing, I think, about two other arguments that are irresistible, but I think in the end, deeply problematic. Two specific doctrines or concepts that loom quite large in equal protection analysis, but that I believe will not serve the trans community well in the long run. And then I've got a tentative suggestion about an alternative approach, not in the belief that it will easily find purchase today, of course. So the first of these is an argument against immutability, right? Who cares if someone was born this way? Over-reliance on the immutability rationale in anti-discrimination law generally is especially problematic in the trans context. A first very important note about immutability is its compatibility with a tremendous amount of subordination, marginalization, and prejudice. It is perfectly possible to regard an entire group as congenitally inferior and then think discrimination against them is inappropriate because they were, after all, born this way. It carries a heavy implication that had they been given a choice, they would have been born otherwise than they were. 14th Amendment arguments in the anti-race discrimination context, and then by extension in the sex-gender context, including the sexual orientation context, all too often have relied on immutability as the preeminent justification against discrimination, reasoning that it is unfair, irrational, morally wrong to discriminate against someone on the basis of a trait not under an individual's control, not the result of a personal choice. This rationale appears in the strict scrutiny cases, of course, but it also appears in intermediate scrutiny cases, including, for example, those protecting the rights of non-marital children from the consequences of the decisions of their parents. It appears in Plyler against Doe, protecting undocumented children from the immigration-related choices of their parents. In each case, the unspoken assumption is that had they been given a choice, they'd have chosen otherwise, to do otherwise, to be otherwise. If this is not an inherently subordinating model, it is surely compatible with or susceptible to a subordinating politics. The immutability versus choice-based model is individualistic, even atomistic, rather than structural, and seeks to distinguish sharply between being and doing, between identity and activity. It makes it impliedly perfectly all right, perfectly constitutional at least, to discriminate against someone for membership in a group which they entered voluntarily, or for conduct expressive of group identity. It licenses discrimination based on membership in a group which a person could, at least in theory, exit voluntarily. It also ignores or sidelines anti-essentialist or structural analyses of discrimination based on group membership, and even of group membership itself. When we treat race as immutable, for example, we ignore and effectively deny the social construction of race, the many ways in which race and the various races function in law as creatures of white supremacy, whose reality is political only. Immutability analysis thus reifies groups whose existence is often the product of bias and discrimination rather than the grounding for it. It puts the burden on victims of discrimination to establish the immutability of the group and their membership in it, which only evades the question Justice Ginsburg posed. The burden should rightly be on those who seek to deny their fellow citizens and residents opportunities for full participation in our polity. For sex and gender, immutability analysis has a special problem, which forces many defenders of trans rights into an uncomfortable argumentative position. At one level, immutability about sex or gender squarely contradicts trans existence. This is the idea found through the Trump administration's executive orders that biological sex is immutable, that gender consistent with that sex is also immutable and fixed at birth, if not before, right, the conception point made. If defenders of trans rights then want to employ this analysis, they must construct a notion of trans identity itself as the immutable trait, the non-alignment or incongruence between the sex assigned at birth and the person's gender identity. Not only does this further entrench sex-gender binarism, but it is not at all clear that it reflects a common, much less universal, lived phenomenology of trans existence. Let me say again, trans rights should not and must not depend on a person always having understood themselves to have a different gender identity than that associated with the sex to which they were assigned at birth. Let me say also that a feminine or masculine gender identity is not a monolith, something the trans community, for example, by developing notions of trans masc or trans femme, has taken in much more thoroughly than many cisgender communities, including feminist communities, have done. Even for cisgender women, there is not just one way of having a feminine gender identity. that again does not necessarily reflect a common, much less universal experience. Coupled with medical gatekeeping, trans immutability enforces a normative performance of lifelong gender incongruence with sex assigned at birth that may not reflect individuals' lived experience of sex and gender as more fluid and changeable over the life course. And Alex Chen is doing really interesting work on reconfiguring detransition as retransition, right? Really interesting stuff. The second of the arguments in this category, the arguments I think we have to let go of, despite sometimes their strategic usefulness, is animus, or what sometimes comes up in the cases as bare animus. And what I think is wrong with trying to use animus to ground an analysis is that no one imagines themselves to bear animus towards some group for no reason whatsoever. They have reasons. They have bad reasons. And we have to engage with the reasons instead of denying that they exist by adhering to a kind of liberal Platonic ideal that if only they knew more, their prejudices would go away. Many deeply prejudiced people have an entire system of beliefs undergirding it, and being told that their beliefs are irrational only leads to them saying, no, they're not. Here are my 10 reasons. We need to engage with the reasons, which is what brings me to, is it a glimmer of hope? Is it the future possibility? And that is to use, if we are still to some degree constrained by equal protection analysis, a robust idea of what counts as an illegitimate governmental purpose for a classification or a law. To marginalize, to subordinate, to deny the existence of persons, to make it impossible for them to obtain and maintain medical care in the identity in which they wish to live. These are illegitimate things for the government to be doing, and they should be engaged with on those terms.
Wow. So this was amazing, both of you. And the good news is that I don't have that much to add on what is the right constitutional argument. And I'm eager to kind of build up on what the previous panel started talking about, which is my current piece about white nationalism and transgender erasure. So kind of how the attack right now on transgender people is actually, I see as a form of white nationalism, and how it relates to the attack, to the racial attacks that are happening in this country. But I do want to add just one point on the constitutional front, which is that throughout my scholarship on trans issues, which dates back quite a while back, I've been concerned about the anti-discrimination framework, precisely for those reasons. And I have always been an advocate for arguing from liberty as opposed to from equality. That's also just like kind of my tendency to go for freedom rather than equal, because the equality framework has brought us down. This is not only in the last 10 years, this is from the very beginning. In fact, the whole concept of gender identity we have created and used as a legal and social concept in order to fit into an anti-discrimination framework. Now we're in a moment of a backlash against it, and that explains kind of the whole moment around redefining sex through the executive branch as quote-unquote biological sex. It is all a kind of a reaction to the last 2 decades in which we've been going to courts with amazing attorneys, but I think arguing uncomfortably within those limits of immutability and gender identity and all of that. So right now the attack is really, we can't say gender identity anymore because that's not a word we're allowed to say anymore. So now we need to kind of conceptualize again. Hooray, we could talk about freedom. We could talk about the 13th Amendment. We could talk about the freedom to express oneself as whatever gender one might want to be today or tomorrow, and not be bound to comparison to cisgender people, cisgender white people all the time. We have to stop that. So my scholarship has been shouting that, and finally I'm invited to all these places to talk about it. So that's my take. Okay,
that was beautiful. Thank you for the truth and the law. And the poetics and the passion. I'm going to ask you another question, but before I do, I thought I would just, the professor in me can't resist just saying the ways in which each of you invoked a very particular and distinct constitutional argument. And Dr. Wilson, you, in the law part of your discussion, talked about discrimination based on sex using Gorsuch's, what one of my colleagues calls gay math argument, from Bostock in that context. And this is the so far standard, right? Trans rights constitutional move is sex discrimination. And we already have heightened scrutiny for the quasi-suspect class of sex, and it belongs in there. Professor Kemker, where you were talking about two very problematic arguments that you have. One, immutability, which is one of the characteristics of trying to establish transgender people as their own quasi-suspect classification under the Equal Protection Clause, meriting heightened scrutiny and the burdens that immutability carries. And then the animus concern comes from, even if you find there is no suspect classification, and we're not arguing for heightened scrutiny, even under the most basic rational basis review of legislation, you cannot, or the courts have said you cannot, bare animus cannot be a justifying government interest. And so you invoke two different kinds of constitutional standards that you're worried about. And then finally, Professor Ben-Asher, the claim for liberty and freedom really operates as substantive due process, right? Making arguments under substantive due process, both for trans individuals, maybe, but maybe not, parental rights, and any number of other things. So in some ways, without even naming them as such, each of you sort of articulated the concerns or possibilities, and then adding the 13th Amendment to that is really important. And that's actually where I want to, what I want to use to frame my next question for you, which is how non-accidental it is, and this has been a theme of various panels throughout the day, how non-accidental it is that the attacks on trans people are coming from the federal government at the same time that they're coming for hand in hand with attacks on DEI, the teaching of Black history. Shanae Watson-Whitaker said, if you come from one of us, you come for all of us. And Professor Goodwin also invoked Martin Luther King, right? I refuse to segregate my moral concerns. So I'd like to actually use your invocation of slavery and yours with white nationalism to ask you to think even more explicitly about how transgender rights are bound up constitutionally and beyond constitutionally with race, ethnicity, citizenship, immigration status, poverty, and think about a justice worth its name, what that looks like. How might we work in coalition with other targeted communities, harness other rights more broadly, work toward constitutional protections that strengthen liberty and equality, that the kind of liberty and equality that we actually want and that would nourish us.
Well, just to kick it off again, I suppose, I would say I think we really have to be serious about understanding anti-Blackness not just as a kind of social condition, but as a supra precedence, right? Slavery itself isn't about this idea of just hating Black people. James Baldwin used to say, you know, if Black people didn't exist, you'd have to invent me for this country to work, right? And I think that's the truth. So I think we have to be serious about this idea when we think about slavery, chattel slavery, but also about the Black codes and the slave codes and Jim Crow. This isn't just specific about keeping Black people down. It's about this idea of the democratization of citizenship, and citizenship itself being co-terminal or coexisting with the notion of whiteness. So if you allow Black people into citizenship, you're necessarily diluting white power. And the same thing is happening if you admit this notion, as you've said, right, of transgender folks, particularly transgender white people, as being people. And being legitimate and being legible and being deserving of dignity, because now you're diluting this notion of whiteness itself. So once again, this idea of whiteness and white supremacy and white superiority and whiteness being at the top of the legal and social order in society, it continues to become diluted the more people that you bring into citizenship, because these things at the founding of the country are interchangeable. And not only were they interchangeable, we're talking about whiteness as white middle-class manhood, right? So if you're broadening what means and who can be a man, my God. Right? Now you've disrupted all of these kind of super logics and precedents that undergird our Constitution. So I think that we have to be clear that there are kind of three things really that kind of that really bind our legal process in this country, going back to the Federalist Papers, even back to the Magna Carta, perhaps, right? You have your triplets of capitalism, right? Sexism or cis heteropatriarchy, and anti-Blackness. And these things are always fighting for the next way, and you quoted Derek Bell in the kind of interest convergence moment, to always kind of make sure that whiteness as property continues to exist. And if we're not clear that that is always the same enemy morphing itself over and over and over again, we start doing its work for it, right? So I think that the question isn't, do we need new coalition partners, or how do we make new coalitions? No, it's keep your eye on the ball, baby. All that thing did was change its hairstyle, and it's mad because we're getting a little trans too, right? Copying the playbook. Can
I add to that? I feel like I agree with every word. And I have been processing my anxiety in the last several months as an immigrant, Jew, and transgender person.
Jesus.
By kind of really diving into this understanding that came from within, that this is actually a moment of racism, even though I'm full of fear. I feel that this is a racist moment per se. So what I have been doing is I started reading about, and this was going to come at some point, the Nuremberg laws. So the Nuremberg laws, for those in the room who are not familiar, are the race laws of 1935 enacted by the Third Reich, toward the beginning of the Third Reich. And here you will be surprised, I think, or at least kind of like, it's really interesting what I found, that in that rally, this was a Nazi rally at the beginning of the Reich, Hitler's already in power, he enacts laws around citizenship, basically stripping Jews to second-class citizens, flag laws that are less relevant here, and then immediately there's also persecution of homosexuals, right? In what we saw in 2025 with the inauguration was an executive order on immigration, immediately taking citizenship, going after citizenship, and DEI, going after Black citizenship, immigrant citizenship, and transgender people. So we see in those same moments of rallies that are MAGA with all the force of the party, they're going after citizenship, they're going after race, and they're going after gender and sexuality. And so in that moment, it was a relief to know that we're all in this together. This is a moment that I think, obviously, we need to be very careful in how we construct the analogies, but this is definitely a moment of white nationalism, and has a lot of legal implications for us in the room, even if they're not constitutional. There's so much law going on. There's so much working through executive power, through unilateral theories of power, through silencing Congress or getting Congress to sign on. So, for example, in the Nuremberg rally, he brought the parliament there. So the parliament allegedly signed those laws, right? And the courts immediately started enforcing them. But they were really silenced. It was all about him. It was all about Hitler himself. And so that's kind of the beginning of my ongoing project about white nationalism as it relates to an attack on transgender people.
And if there's one thing I can add, and I was sort of waiting to see if this would get mentioned, and it hasn't, and I think it very much needs to be in the conversation, and that's the category of disability. Right? Jamelia Morgan's work on disability and race is fantastic on this, that the American legal conception of disability is one of those many emanations of the law of enslavement, and medicalization, pathologization, medical gatekeeping for trans people. That's the other dimension, right? Of all the categories that you mentioned, that was the one that was not mentioned, and eugenics and the third right. So that's all got to be in the package as well. And without taking more time than is fair for me to take, I think it is another of the dangerous, although strategically quite useful methods, right, that are being used for the protection of trans rights, especially in the carceral setting, accommodation to disability, et cetera. And Dee Dangaran and Sean Lewis are doing great work on this, but it's kind of a hot potato, right? What's the best thing to do for the clients you represent versus what kinds of ways of thinking are being laid down about this identity?
I just have one sentence to that, maybe. Maybe two, maybe three. No, I mean, like, because you asked, what do we do, right? What is the strategy? It's simple. Tell the truth, right? All of us are professors. How many times have you gone into, and I teach con law and criminal procedure and criminal law, how many times have you gone into your class, and you've just said, oh, this is the logics of law. This is the canon of construction. This is the rule. These are the elements. And you're not being really honest about the way this operates in the world. And I remember when I was in law school, one of my peers this year, was my little upper class mentor at the time, but I was always going crazy. I felt like, oh my God, you're telling me this is what the law is, but I know I do not have this right. I know how the police are going to treat me. Am I dumb? Or are you dumb? I was really struggling, so I've realized, like, we're thinking about this political moment that you brought up, and like so many people in this country are like, no, we don't want to fight for these institutions because these institutions have been the ones that have been screwing us over for generations of generations. Why am I fighting for democracy when democracy is anti-black? Right? So like, why am I fighting for you when you fighting with him? Both of y'all my enemy. What's going on? And it's because no one's telling the truth. Right? And so we have to get back, and I'm wearing the bell hooks, shout out to Bell, shirt that really just says, the classroom is still the most place for the radical possibilities for freedom. And it cannot be that if you are submitting in advance and you don't tell the truth. So tell the truth about the lie beneath the law, and tell the truth about the rhetorics of the law and what is always already sought out to do. And who has been the cannon fodder for the systems that we live under.
Can I just add to that, too?
Yeah, you may.
About the truth. This is relating to the truth. So the truth about the Nuremberg laws, and this came from an American legal scholar at Yale, is that they were devised after American race laws.
That's right.
Around slave,
And blood quantum.
Yeah. So when the Nazis were thinking about how to discriminate against Jews, they went to the Americans to see how they discriminated against Black people, and they went to the marriage laws specifically, because this is how you create a race. You prevent marriage and you prevent sex. So this is not, I'm not just making up analogies. The Nazis went to the Americans, and in fact, the good Nazis thought the Americans were too radical, too harsh in their racism, and they didn't want to look that racist. They wanted the world to accept their anti-Semitism. And so, yes, that's another point of truth about America.
Okay, so.
That's the truth.
It's the truth. I mean, it's actually, I feel like so many of us professors go into the classroom, especially into a law classroom, and you teach the law, and you want to believe in it, and you want your students to believe in it, because the only thing worse than believing in it is not believing in it. And yet, right, like when it conflicts with the truth, you also are standing there thinking, they're thinking, am I dumb or are you dumb, right? Like, and one thing that sort of, everything that each of you said was beautiful and true. And it makes me think a lot about the first point you made, Dr. Wilson, was about the democratization,
Just a roll that
That I put a little extra syllable in there.
sauce on
Just
there.
a little,
That's all right.
it was saucy, wasn't it? Democratization.
Just go to the next part of the sentence.
Of saucy citizenship. And what that the radicalness behind that idea, right? What the radicalness that everyone might be legible. And that comes with thinking about actually telling the truth about what's going on right now is not to just trade in just the arguments we've been taught might apply to a subordinated group, distinct from and irreconcilable with other subordinated groups, but to actually think about what democracy might mean precisely at the moment when democracy is at its most vulnerable. And so maybe thinking about, and this might be constitutional, might not be constitutional, thinking about creative ways to connect this, again, with the heteropatriarchy, with the hypermasculinity, with the capitalism and the ostentatious disparities of wealth, and with concrete spoken anti-Blackness, right? Those three things, and what that means, how all of those have been utilized as a sort of tools to attack democracy, and maybe just making it bigger still.
I'm trying to
Is that a question? Is there a question?
Is there a question? So I guess,
Council, is there a question?
I thought there was. Maybe, was that a statement?
That's all right.
If I make a statement and I raise my voice at the end, does it turn into a question?
Up talker? You're an up talker?
I mean, I think that, to answer your question, not question statement. No, I think that, there is something there. I mean, we're thinking about all these things, the economic systems, the systems of social subordination, whether it's racism, sexism, hetero, whatever, xenophobia, all the things, how they're colluding and colliding, right, to create a system of benefits of power that orders and disorders the way certain people live and die, others accumulate wealth, and other people are the things that are accumulated, right? People accumulate wealth, and other people have their wealth extracted from them. And if we think about, going back to Hobbes and the crazy Western philosophers, the idea of, wealth itself is this idea of you pick up this bundle of sticks and you imbued part of your life force into this thing. So when we're thinking about extracting wealth, we're thinking about extracting life. We're thinking about a slow murder. We're thinking about a legitimized murder via the laws that we have, right? So in all of these systems that we're saying, and we speak the truth about them, we're really saying this isn't about democracy dying. It's about the realization, the witnessing, and the testimony of a democracy that never was. Right? So people, I think at their very bare minimum, and particularly people of color, women folk, trans folk, new immigrants, poor people in this country, have long understood there's never been a democracy. You've never had an equal say. Your vote never counted as the same way as everyone else. And you're being gaslit by people saying, let's save democracy. Wait, for who, girl? What you talking about? I ain't never had that. And if I had, I don't want that no more. Take it. Right? And so I think the truth of this is getting to this kind of space of reimagining. I think Dorothy Roberts talks about this in Abolitionist Constitution, or toward Abolitionist Constitution. Is actually trying to midwife what a democracy looks like. And I think when we go back to early narratives of enslaved people, right before emancipation, then after with the Freedmen's Bureau, you start getting these freedom dreams, and Robert D.G. Kelly writes about this, of what a democracy in America could look like. And it scared the hell out of people of power, right? And I mean, David Walker gave a speech, David Walker's appeal, and shortly after he went missing. Right, 32-year-old black person, 1832, gave a speech in Boston, wrote this in pamphlets, put it in suits, sent it down to the South, critiqued the whole country. It was a clap back to Thomas Jefferson, right? And it was basically, it's called David Walker's Appeal to the Colored People of the World. And it was written in 4 articles. And it was basically, each article was a slap in the face to Thomas Jefferson for his racist and racist and sexist and weird racial Christian views. And he clapped him down every single way, going back to the Greeks and the Romans. I said, baby, it's 1832. We ain't got the internet. How you know all this? Right? I fact-checked him and he was right. But that was a moment of truth-telling, right? But instead, and I love him, and I always go to his house over here down the street. But when we think about folks like, oh my goodness, what to the 4th of July was a Negro? Frederick Douglass, right? He tried the other way. And he said, let me invert the language of this Declaration of Independence and indict you. What we've realized is that power has no conscience. You cannot indict and convict power. Instead, you must create something new.
Love that.
Love that.
So
Questions?
I do want to open up. I have one more question for you, which is sort of going off of that, which is, we're talking about constitutionalism beyond the Constitution, right? If we're, I love the idea of midwifing what a democracy might be, and it needs something more than litigation. And I think Alexandra Brodsky this morning said something like litigation has sort of killed my political imagination, or constrained, litigation can constrain your political imagination. And I would love for you all to sort of, ways you think about the mechanisms, the avenues, the ways of intervening in language and conversation, in friendships, in institutions, and in politics more generally, to fortify and expand our imaginations about what is not just constitutionally possible, but democratically possible, what we want it to look like, and how to begin that work. Just a little tiny question.
So your questions are so rich. There's so many things to hold on to. So I don't want law students in the room to leave this panel and others thinking, oh, the law doesn't matter or the Constitution doesn't matter. Because I don't think any of us really think that. So I think that
Maybe it doesn't matter in the way people sometimes think it does.
Right. So I want to make law school more interesting for you all. Law matters a lot. The question is, what is law, right? If we think about it as this, this like metaphysical thing out there, and we need to argue for the Constitution, the correct constitutional right, and fit within the right frameworks and cite all the right case law, we're going to be disappointed and bored to death. It is so boring. And I call that case crunching. It's good. We need to do it. You need to get better and better at it. But that's not what it is, right? That's not where the passion is. So I'm very passionate about understanding how laws work, and specifically, and here I'm a very serious legal realist, how law works as a form of power, and specifically through creating exceptions. That's one of the ways where we create a lot of rules, and then there are exceptions. And conservatives and Republicans are awesome at it. They find the exceptions and they boom them into the rules. They've been doing this for 2 decades. It started with it became really large around the Bush administration, around Guantanamo Bay, around the fight, the war on terror, right? This is where the playbook appears, where you make rules that are for the good people, and then the exception is you can torture all the others, right? You can suspend the rule of law, you can have the Patriot Act, you can have all these ways in which people become less than human, right? And then we see an exaggeration of that after with Hobby Lobby, with religious exemptions, right? We can create legal exceptions, realist exceptions through religious, kind of what I've called black holes, right? Where you can create areas where the law doesn't exist, and where the law doesn't exist, there is subordination, there is power, there is the police, there is force, there is humiliation. So I think as kind of law scholars and students, we need to find those places and inhabit them with humanity, with excitement, with new things that are not law, that are narratives, that are new, that are, and not let the police take over, the police broadly defined, take over those spaces and abuse us, all of us. So that's kind of my optimism about how law does matter, just in a different way.
I guess I would say just a few words, and again, right, these questions prompt so many things. I mean, as soon as you started talking about spaces where law doesn't matter, I was thinking about Taylor Sheridan and Yellowstone and the toxic masculinity of the recreation of the West, including a hero who is a feudal lord who, has a section of Yellowstone National Park to do his murdering because allegedly it's beyond the reach of the law. And the cultural reception of these products, right? Many people who will never read cases, right, are consuming, reading, right, the visual and popular culture of our time, right, in ways that have all kinds of implications, right, about the way they understand what it is to be an American, what it is to be a man, right, et cetera. So I think that's part of it. I think part of what we can do in a law school classroom is help our students to become more critical consumers of everything, legal and non-legal, that they see. And this is, as much of a cliche as it is, a little bit of a be the change you want to see, right? If you democratize your pedagogy, democratize your law school to the extent that you can. Think hard about place, in the aftermath of Dean Trainor's very well articulated statement. I cannot speak for people at Georgetown, but I would hope that all of you breathe somewhat easier than to see the utter capitulation or silence of other leaders. I'd like to say courage is contagious. It's not clear that it is, right? But cowardice is, right? That's for sure.
Yeah, just to be really quick, I know we're low on time. I would say that, when we're thinking about how do we show up differently, what do we do maybe outside and beyond law, think about and be mindful of how you respond to harm, right? Law is nothing more but the legitimization and the regulation of violence. And so violence is about what do we do when we feel threatened? What do we do when we feel wronged? So if you want to think about, and if you want to create a world outside, beyond, and maybe in spite, and through law as well, that is more humane, you have to deal with, one, what do you do to yourself when you feel like you've messed up and you've done wrong? How do you argue with your partner? What do you do when you're misaligned with your parents? What happens when your children or even your ex gets on your last damn nerves? How do you respond? Do you take a step back and breathe? Do you look for vengeance? Do you look for reparation and care? Right? How are those politics exhibited in your day-to-day, your moment-to-moment, particularly when you do not have the answers, right? And when you look at that and you take stock of that for a few days, a few weeks, you actually illuminate what your own politics are. And you can give yourself a pathway, a lotus star, a navigational compass to get to the creation of the world that you want to see, and perhaps a new jurisprudence of being.
I'm inspired.
I don't feel like I should say anything after a new jurisprudence of being. Like, that is where we should end. And I'm being cued that it's time to wrap up. At the same time, good timing. I wanna open this up. I want to add one little thing to this question of when is law? And just say, when we think there is not law, at least the way I think about this, as law integrated into a world of exceptions and exceptions to exceptions, when we think there is not law, it's usually not the absence of law, it's usually law not interested in the harm that happens in that space and not interested in the pain that's felt in that space. There is still law there, and it's law giving people permission to hurt each other. And so I appreciate sort of the jurisprudence of being, because those are the places where we actually make those decisions about how to create norms that are the beginning of law that we want to see in the world. I would love to have questions from the audience for these panelists.
I just wanted to thank you all. It's been phenomenal listening to you. As a litigator, I feel like the things that you've said, especially having spent time in the LGBTQ space and litigating, I've been constantly thinking about the ways that we leave people behind. And something that comes to mind often in this work is Ketanji Brown Jackson's dissent in SFFA. There was like a powerful line that everybody kept running with, where she was talking about how the decision would essentially render, Black people and minorities prepared for the bunker and not the boardroom. And while people found that to be so powerful, thinking about the lack of access to the boardroom, I was wondering about, for those of us who are in the bunker, like who gets who's allowed to experience violence and also be a tool for violence. And so like a question I have for you all as I'm thinking through this is like, what does it look like in this moment when we're talking about like the ways that we can be creative and the ways that we can kind of re-envision liberty or think about how to, shift the Constitution to the extent that we can. I guess, like, do you have words of warning for us, actually, about who we will end up leaving behind? Because I've always thought about that when it comes to non-binary people, when it comes to intersex people. So who are we leaving behind for violence?
Just to start, I would add that, we should maybe be a little critical of the word, creative. Something that we're encouraging people to do. By your mere existence, you're creating, right? And we should maybe be more mindful of the subconscious creating that we're doing. The subconscious laws of being, the subconscious jurisprudence of being, right? That we create every single day with the decisions that we make. So you're always creative. The question is, what are you choosing to be cognizant about, right? So I think that's the first part. The second part to your question, which I wrestle with a lot in my day-to-day and just, coming from where I come from and being where I'm at now, is, that question of like who is living left behind and who's being readied and available for violence. And we already know the answer to that question because who's in the spaces we're able to go to? We've already left them behind, right? So the question is like, who have we remembered to forget? Right? And so I think we can take a look even in this room where we have a little bit of diversity. We know who's left behind. They're not here, right? We see who's able to speak, who's called to speak, who's seen as being able to be a legitimate witness, or we might call it an expert, right? So I think in many ways we know that, but I think that the practice I think Bell Hooks gives us and Audre Lorde gives us and Pauli Murray gives us is the kind of purposeful rememory, Toni Morrison, right? The purposeful rememory of the things that have happened, the people that are left behind, and what are we doing to make sure that we're not just called to carry someone, but in that old, Kojic Church of God in Christ gospel way, we got people walking with us, right? At all times. Whose hand are you holding, right? And if you ain't holding nobody's hand, you've left far too many people behind.
Absolutely. You want to answer? Yeah. I would just add to this, I absolutely agree. That at this moment, this question came up in most of the panels, and that just was part of the question of like, what do we do at this moment? Right. And obviously, we have different responses and different obligations, moral obligations towards ourselves and towards others. But for me, and I encourage people, to at least consider it. We know how much we cannot change at this moment, and we can be kind of students of fascism. Understanding it and documenting it for next generations, to tell them what happened, to tell them how those people went from Venezuelans went somewhere else, to tell them that we were here talking about it, that we combined together and we heard poetry, right? So I think there's a lot of value to documenting the moment, to be interested in fascism as it is happening and really taking it in and reflecting it out in the world in different ways, in writing your briefs, in writing your poetry, in presenting yourself to your partner, right? Because this is what we're right now in, and it's a very powerful moment with a lot of energy. We just need to know what to do with it.
Also on and offline, because who knows what's going to happen with internet and servers and things. I think it's so important. I mean, Ida B. Wells gave us a red record, and that's how we know the lynching epidemic was not about black men running around raping everybody. It was about white men and their power and wanting to own white women and keep political power over black people, right? Otherwise, we would have believed the newspapers. So it's an importance there, seriously, to really keeping that sometimes red and bloody tabulation of the moment, so you can really get to the truth of the matter asserted.
Yeah, wonderful.
I think we have time for like one more question if anyone has something. Maybe not.
Hearing none.
Closing remarks.
I feel like Sienna, you should get the last question.
When there's a paper.
The one thing I didn't ask any of you was the question that I think every panel asked at the very end, which is, how are you coping? What brings you joy? What are you doing? We may be beyond that at this point. We're like at radical reimagining.
Yeah, I mean, the children, right? I have so many nieces and nephews. And so for me, I'm always amazed at the things about society that are terrible that they don't take for granted, right? They don't assume that people have to be treated differently. They think it's nuts. And I'm like, oh, they're like, you're not outraged? I've been outraged for 30 years. I don't know. This is my outrage face, right? But just that beauty, and not just the innocence, but the idea that like, these little 6, 7, 8, 9, 10-year-old Black kids like, yeah, and there's all these other genders too. I'm like, yeah, I thought I studied this, and all that, right? But there's nothing stopping them. And they don't believe that they can be stopped. And of course, there's always the great things like bourbon. It really helps in times like this. Poetry, the ancestors. Yeah. No tax on bourbon.
Homegrown. Yeah,
Joy or radical reimagining?
I mean, some of this is just carrying on, right? And not feeling like finding ways to take joy in your daily life and your intimate relationships and the books you read and the books you write, that's okay. Give yourself permission to do that. You've got to refuel. You've got to nourish yourself in some way, right? As outraged as we all are, it can't be an endless outrage machine.
I'm so grateful for you all
Thank you.
showing up here today, speaking about truth and law and
Lies.
and lies. And truth.
Yeah.
Thank you so much. Let's give them a round of applause.
Thank you all. That was incredibly wonderful. Another round of applause, please. All right, I know you all are itching to get to the happy hour. I have a few quick things to say, I promise. First, thank you to all of our speakers for donating their time and delivering such wonderful remarks. Our sponsors, the Gender Plus Justice Initiative and the Office of Journal Administration. Attendees for coming, thank you for showing up and making this a reality. The Georgetown Journal of Gender and the Law staff, I love you all very dearly, and this would not have been possible without you. And our thank you. And finally, our wonderful faculty advisors, two of whom are here and spoke today, Professor Naomi Mezey, Professor Michelle Bratcher-Goodwin, and Professor Deborah Epstein. We are in awe of you and inspired by you. And finally, very quickly, I wanted to flag that March 31st is Trans Day of Visibility. The Christopher Street Project is organizing a march here in DC at 4 p.m. at the National Mall. We encourage you to participate, to show up for trans folks. And remember, Trans Day of Visibility is it's a joyful celebration, and we hope that you'll celebrate the trans folk in your lives on that day. Finally, it is time for the happy hour. I have 3 lovely assistants up here who will direct you all through the door between this building and the adjacent building where the happy hour is. Yes, they will head to the front. Please follow them. And thank you all.